Good evening, everybody. Welcome. You will note that I am by myself today. My dear friend and colleague Sam Shihab is doing some traveling today. He will be back with us next week. But what you get is a solo Brian session where we are going to talk about, well, whatever I want to talk about this week. And what I want to talk about is trends in employment based immigration as I'm seeing them in September 2024. Bam. I am Brian Burke of Shihab Burke. I am an immigration attorney. We practice out of fabulous Dublin, Ohio. And what we're going to do for the next half hour or so is we are going to talk about, my immigration topic of the week. And then after that, I'm going to have some fun answering your questions to the extent I can here in this interesting live venue. So without further ado, what I'm going to do is I'm going to hit my sort of talking points on the subject of what's going on in the world of employment-based green cards in September 2024. And I guess I'm going to start with the most interesting one first. Interviews. Interviews are still happening for people with long pending employment-based green cards with priority dates that are nowhere near current. Why are they doing this? I don't really have an answer for you, but I am consistently getting emails from clients saying, "Hey, Brian, I have an employment based green card interview. My priority date is in 2014, something like that. Why am I getting interviewed? I don't know, but they are still happening." So, employment based interviews happening for people without current priority dates in 20 September 2024. Now, great. Um, Definitely employment-based green cards are happening for people without current priority dates. They're happening for people with current priority dates as well. But I figure we'll talk for a moment about why, do I have a definitive answer? No. But I will talk to you about why I think those interviews might be coming in. Well, my optimistic theory is that great interview notices are coming in for people with out current priority dates and pending green card applications. They're coming in because the good folks in the government are trying to get on top of their cases. Um, they are basically hoping to have your case reviewed, ready, away, ready to go when your priority date eventually comes up. The ideal, the dream is when your priority date comes up, the beginning of that month, they pick up your case and approve it, and you're done. That's a dream. I would say for a lot of people, that is not the reality, though. I mean, I can think of somebody, a very nice gentleman here in the local Ohio area who, I went to an interview with him about 2 years ago, and his priority date finally became current again. Oh, maybe I think it was either in June or July. And it took him a couple of months to actually approve his green card case. I think maybe at the beginning of this month they actually approved it. So USCIS is not really that organized, not that on top of things. But again, that's somebody who had a green card interview way before they actually get their green card. And well, I guess the bright side is they were actually able to issue that green card, get that into this nice gentleman's hand within a couple months of his priority date becoming current. But again, my topic for the time being is interviews are happening for people without current priority dates on employment-based green cards. And I guess one of the most interesting implications for me is that, hey, look at that. We have somebody in our chat saying hello. I guess I'm going solo here, so I don't have the benefit of having somebody to tell me, one, whether they can hear me. It sounds like you can. And I just remind everybody, toss your questions into the chat. It makes the back half of this presentation a lot more interesting when I have commentary on what's going on in the world to chat about. But I guess the interesting thing for me, especially people from India and China and long pending employment-based green cards, is that the fact that they're interviewing people regularly without current priority dates means that there's always an ever-looming threat that that interview could happen and USCIS could ask you for that I-485 supplement J, which is sort of a stress point for me because lots of people, and even in this audience here, while they're calling me on the phone or in this venue, will say, "Hey, can I take a long break when I have a pending employment-based green card?" And the conversation we always have is, in theory, that might be possible, but gee golly, I sure as heck can't recommend it. And this is the reason why. As soon as you're asked for a I-485 J from USCIS, you have a deadline looming. That deadline could be, I mean, let's say you have an interview, you get called into interview. Interviews can be scheduled as like 2.5 weeks out, crazy fast, and then suddenly you're in that interview room with USCIS, and they're saying, "Hey, where are you working?" And your answer is, "Ooh, I don't have anything at the moment." That for me is a likely scenario to get you either one, a notice of intent to deny after the interview, giving you a 30-day response period, or a notice of or a request for evidence with an 87-day response period. That is a can be a tough amount of time to find and get a job. And as you guys likely know, if you can't produce evidence of an offer of permanent employment in the United States on Form I-45J, that can lead to a denial of a green card application. It is scary stuff. So, interviews are good. I like interviews in that they make me feel good that USCIS is actually actively looking at cases and are maybe trying to achieve that goal of being able to give away green cards as soon as somebody's priority date is current. Because I guess for the average person, what I don't want for them is for USCIS or for their priority date to finally become current, then have USCIS look at their case for the first time. But those interviews can strike as a bit of surprise to people, and you have to be prepared for them. And the best way to be prepared is to, look like a guy whose case they can approve right now, um, rather than a guy who they need to think about a little bit. On that same note, I guess I have another theory is, people that they're interviewing might be people with interesting cases, interesting employers in their history, employers that they've investigated in the past, wanting to ask about, you know, the classic sort of things they might ask somebody who's on an H-1B visa, particularly an IT consultant, during an interview. Have you ever been benched by your employer? Have you ever violated terms and conditions of your immigration status? Have you ever lied to us? That sort of thing. That's the sort of thing they really like to do in person. Um, I guess the bottom line is interviews happen. They don't always happen, but whenever interviews happen, especially right now in the climate we're in employment-based immigration, they're not interviewing everybody. If you're being interviewed, you're being interviewed for a reason, probably. You may not be able to figure out what that is, but take your interview seriously because USCIS does. Um, so there is that. Um, Big picture. So one other thing on the subject of interviews. So I'm here talking a mile a minute. I'm left by myself, so I don't have my partner Sam to keep my pace down. So I apologize here to everybody for that. But the other thing about interviews is I mentioned that they're not interviewing many people for employment-based green cards right now. One thing when I think about interviews is the present political climate we're in, and it's more of the fact that there's a presidential election coming up. There's a presidential debate tomorrow evening. I'm going to be listening to that, and I'm to the best I can anyway, and looking to see if they say anything about immigration. But I don't hold my breath for it being about employment immigration. However, one thing that changes interview practices, USCIS, is policy from the top in the executive branch. To give you an idea, during the prior presidential administration, uh, oh boy, they were interviewing everybody, all family, all employment cases. This guy was being dragged around the country by both ears to attending green card interviews just because people wanted to have an attorney there, people who are perhaps a bit more nervous about these things than most. But something to keep in mind if there's a change in administration and more likely a change from, there's going to be a change in administration regardless. We're going to get a new president in 2024. The question is who it is. I guess if we see another Donald Trump administration, I would expect a return to similar practices as we had then, interviews for everybody, which I guess is a little bit concerning in that in the present climate right now, when they only interview a select few for employment-based green card interviews, to a high degree of not a 100% certainty, but to a fair degree of certainty that there's something serious that USCIS is interested about for that interview. When they interview everybody, you don't really know who's the interesting ones and who's the not interesting ones. So I think I have probably said my piece on the subject of interviews. Executive summary, they're happening now. They're happening for everybody. If you get an interview, take it seriously. And worry, if you that USCIS can sort of poll you at any time on the subject, your best position is always to be employed when you have a pending employment-based green card, be employed because they can ask. So I am still running here at a mile a minute, but that's okay because I have plenty of minutes left. I see some questions and comments coming in. Please do keep them coming in. For those who don't know, I see some new names here amongst our viewers. Please keep let know that I will start getting to those in the back half hour of this presentation because I'm going to keep on telling you guys about what I'm seeing in the world of employment-based immigration. So, um, RFEs. RFEs are still coming in for people with just long pending employment based green cards. I would guess, for the average, somebody who's not in the India or China EB2, EB3 backlog, I would say you're not super likely to see RFEs. I would say the RFEs that those folks are more likely to see are very simple, basic RFEs that would apply to anybody in a family-based green card scenario as well. Typically on things like your medical exams don't look right, or your birth certificate doesn't look right, things along those lines. Those RFEs are universal to everybody, but in my experience, once your case has been filed in i- the bun that is in your case in the oven that is USCIS for a while, they'll usually shake out those RFEs early on. So I guess that's a trend for all types of green card cases. The basic stuff, your birth certificates, your medical exams, those are sort of the basic things that they will sort of look at as a case shakes on a little bit further. And again, the longest pending cases with USCIS for green cards are going to be your India, China, EB2, EB3 backlog. That's when they start asking, I don't know, more interesting questions. Um, for the sort of questions we're seeing are the more interesting adjustment status RFEs are sort of mainly they're targeted at people who've worked for IT consulting firms. Is we have some clients who do in that business who are in that business, and some people just come to us for help filing a green card who are in that business. And USCIS has a perpetual, perennial interest in IT consulting firms, and they are more likely to ask those folks interesting questions in RFEs. They're going to ask sort of the classic questions in those RFEs that I mentioned that might come up during an interview. So, basically, you ever been benched by your employer? Have you always worked for consistently during the time you've been on H-1B status? Essentially, during an interview and during an RFE inquiry, especially one that comes out of the blue, they are looking they are looking to you. They're looking into your history to find if there's any grounds by which they should deny your case. And fundamentally, those RFEs and interviews that seem to come out of nowhere, I can't think that they come out of a vacuum. I can't help but think that somewhere in the USCIS sort of investigatory section is that there's somebody out there saying, look into this person for X, Y, Z. Because I can tell you, I've been sometimes absolutely been flabbergasted by the sort of things that USCIS brings up in requests for evidence or interviews. They will dredge up things from your immigration history that you might have thought were long and dead. A classic example of this that sort of rattles around in our collective head as a law firm is a gentleman who we talked to. Somebody called us for some advice, about a year ago. And the scenario was is he attended a green card interview and they brought up his first visa application, which would have been 15 years earlier. Um, and basically, they took issue with something that happened during his visa interview for his first time H-1B visa 15 years prior, which ultimately led to the denial of his green card. A rough scenario for sure. And I guess, those issues are like that out there. Bottom line is, a lot of people don't have to think about these things. But the other sort of more cynical side of me would be that perfect immigration and compliance is very difficult. I think about people coming to the United States on student visas. Coming to the United States on a student visa. So this could be the immigration attorney in me talking, but I get stressed out about people on student visas because I know they're not getting any legal advice from an attorney like me, and the rules of student visas are complex. And the scenario I imagine is this: somebody comes on a student visa and then changes to H-1B status and then applies for a green card down the road, and they can bring up student visa compliance issues from way down the road, and it can be a problem in your green card application. For example, it's the I was I was working at a bodega near the university on the down low when I was in school. Well, there's a lot of reasons why that can be a problem. There's a lot of reasons why it can't be where it might not be a problem. Perhaps INA 245K, but where it can become a problem if you forget about things like this and say, "I've never worked in the United States without authorization" on your I-45 form. That can be a problem. So those RFEs and interviews as well can dredge up any sort of issue, any sort of your worst dream skeleton closet sort of scenarios. And I guess my general advice with RFEs, I was just talking with a client about this morning, is that when you get one, don't presume an innocent request. Presume um, malice or malintent that is poorly written, because USCIS RFEs in general, they are drafted based upon boilerplate repeat language that they copy and paste to send to somebody, and USCIS officers aren't usually good at sort of free writing the reasons why for their requests for evidence. So and they usually don't give you writing. They just say their RFEs more often than that will say, give us this, give us this, give us this, which without explaining why. And for the record, not explaining why is a problem for an attorney to me to discuss with them, but that's another bag of beans. Um, but I guess treat RFEs carefully. I have had a lot of fun conversations with clients when they think the RFE that they have is innocent when it is in fact a little bit malicious on the part of the government. Perhaps malicious isn't the right term. The government's allowed to do their job. The government is allowed to ask you questions to verify immigration compliance. But I guess these are if you have an RFE on your green card case, talk to an attorney. Attorney, if you're choosing. I like me. I consult myself on all of my immigration legal issues, but there's so many of us out there. Um, Sort of a public service announcement. Make sure if are talking about employment immigration issues, find somebody who does employment immigration. To give you an idea, I'm an attorney here in Ohio, and I'm a member of the American Immigration Lawyers Association. And I once attended a conference here in for immigration attorneys in the city of Columbus, right? And there was people from all around the state, and then they said, okay, in the middle of the day, we're going to split off into the people who do, deportation, asylum half, and we're going to split into the employment half. And basically, they split the room. I thought they'd maybe split it in half. They split it into like an eighth of the room for the employment people, and the rest of the massive crowd of people were doing people who are doing deportation, asylum, removal. Doesn't necessarily mean that if they do those other things, they don't do employment immigration. But there's a lot of attorneys out there who just don't touch employment immigration. If you're looking for one, talk with them and make sure they in fact do employment immigration, because the issues for family immigration and adjustment of status are a lot different from the issues of employment immigration for adjustment of status. It took me years to learn to sort of how to understand the compliance challenges of people on H-1B and L visas, for example, which are common paths to a green card. So topics touched so far, for those of us who are keeping track. One, interviews still happening, even if your priority date's not current. A little bit scary. Take it seriously, because right now they tend to be interviewing people for a reason. I have been to Full disclosure. I have been to interviews in the last couple of years, stating that, hey, um, where I couldn't perceive a reason for the interview after it, but usually there is. RFEs, they're still coming as well. RFEs, we take them as they come, but those of you who have seen a USCIS RFE on a long pending green card application, in my experience, they are cryptically drafted and with questions that can be answered multiple different ways, and they should be taken seriously. And because they might be looking for things that you're not even thinking about when you're filing those RFE responses. So, my next topic is a fun one, just sort of a public service announcement. EB1. EB1, EB1, EB1. EB1 is a popular topic right now. Why? Because I know so many people are in that China, India, EB2, EB3 backlog. And that's not to say it's not a pretty time for the visa bulletin when it comes to the, as I go to look at the visa bulletin right now. Um, the rest of the world, there's still a bit of a wait time for people in, especially in the EB3 category, for the rest of the world, which is something that makes EB1 so popular. Realistically, I mean, for people in our audience, it depends really upon what you're doing. EB1C is the most accessible employment based immigration category in the EB1 category. For those who aren't aware, that is a category that has essentially identical requirements, more or less, as to the L1 visa, L1A visa. Meaning, if you're on the United States on an L1A visa and you're in the EB2 category, or EB3 category, you're probably in the wrong place. I had a consult with somebody earlier this week who said, my company's bringing me to the United States on an L1 visa, but he was originally from India, and he said, but due to the backlog, they didn't think they'd be able to get me a green card because of the 10 to 14 year wait for a green card in the EB2 or EB3 category. I said, my man, if you're coming to the United States on an EB1A visa, EB1C visa, you have a pretty nice path lined up to an EB1C green card. Uh, awesome. It's coming to the United States on an L1A visa, getting a green card in the EB1C category. In terms of EB1A, which is sort of the other big EB1 category, it is possible to achieve. I guess my big sort of public service announcement on that one is, there are lots of attorneys out there who will talk to somebody about EB1A. What times we'll do free consultations. There's people who literally do the entire case on a contingency process, on a contingency basis, meaning unless it's approved, they don't get paid. It is sort of an exciting time to be doing EB1As because we are in a favorable immigration climate with a favorable administration who is more likely to approve cases than I've experienced for some time. Um, the bottom line is, if you are an important person in your field, it might be worth having a conversation with somebody. The worst that somebody can do is say no. I always like doing EB1A talks because I get to learn interesting things about interesting new people I've met, you know, engineers at top Silicon Valley companies, people with cool patents, and learned about fields I've never, experienced before. If you're an attorney immigration attorney who doesn't like EB1As, I don't know. I couldn't explain it because there's such unique visas where you get to really spend a lot of time with an attorney to make you as the client, you get to educate us about, the work you do, and I get to try to absorb it all and sort of spoon feed it or drip feed it to USCIS in a way that can make sense to them very quickly. Always fun cases. Look into them. Odds are, if you're in a field where your friends and colleagues are getting green cards in the EB1 categories, maybe you should think about it too. Something to think about there from on that front. So I guess so. I hit my three big topics so far: interviews, RFEs, EB1. I guess there's one topic that I haven't touched upon yet, but it is politics. There is a presidential debate imminently upon us. As I recall, it is happening tomorrow evening, and I will be on front of my TV, or it's 2024, more likely on a phone or on my computer, just staring at it like this because what happens there shapes the future of this country. And obviously, a lot of the people in our audience are, either non-immigrant visa holders or people just on the cusp of getting a green card. I know there's some people here, green card holders as well. But watch this thing. If you're going to if you have long-term plans to stay in this country, no matter what side of where you think you are politically, it behooves you to be interested in U.S. politics by virtue of the fact that you're going to be part of this country, and the way so goes this country, so goes immigration, so goes your life. The prosperity of this country is good for everybody in it, and there you go. That includes non-immigrants and immigrants. So I'd encourage everybody to sort of tune in and check out what's going on there. Do I think that employment immigration is going to be coming up? No. Do I think that, illegal, you know, undocumented individuals are going to be a hot topic in that? Do I think that the Democratic candidate Kamala Harris would be is going to be absolutely well, the attempt to accidentally bludgeon her on the subject of the southern border. Yes, 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 yes. But I don't think employment immigration will come up. But if it does, I'll be like a guy watching a football game or your sport of choice at home, going yes, 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 yes. It's like seeing your favorite player walk onto the walk. I'm going to use basketball. Your favorite player walk onto the court. It's exciting stuff to see a topic. It would be exciting stuff to see a topic so dear to my heart to come to the national stage like that. I just can't count on it for the time being. Speaking just a little bit more on the subject of politics, maybe it's because everybody's so sort of eyes on the presidential election that I haven't heard really any sort of peeps lately on the subject of employment-based immigration reform. It used to be, it was pretty popular, and usually people I presume somebody in our audience is going to prove me wrong by basically saying, "Brian, have you heard about Bill XYZ that's being introduced on introduced by Senator so and so?" But I haven't heard any really sort of new news of even any pushes for employment-based immigration reform right now, which is kind of interesting. Tell me if you guys have heard anything, because again, every senator and congressman, seems to have an idea about this, but I haven't heard any sort of plans, proposed bills for employment-based immigration reform, and it could be just that we are in sort of a lame duck sort of time with the current president who is going to be leaving office, and everybody focused in on November elections. I don't know, but again, that's another thing that falls in the category of I'm not holding my breath for it. Actual substantive reform on employment-based immigrations, the great one being the backlog. But the backlog, as we've discussed lots of times in this venue, how do you fix the employment-based immigration backlog for China and India? One thing that we've always believed is in reach of executive power is to change the way that people are counted in terms of visa counting. Whereas, I'll give you this example to make it make sense. Let's say you have an I-140 for yourself, and that means you're immigrating. If you have a spouse and you have 3 kids that are immigrating, that's 5 people, 5 visa numbers. It's been theorized and stated that they could change the way to counting is that basically one visa accounts for only the primary applicant, meaning that frees up 4 other visas available for other people. Would be super cool, but again, I don't see it happening in the foreseeable future. So there is that. But politics is a strange beast. If one political party gets sort of absolute control, they have a mandate, and all it takes is just. I mean, I won't go into the civics requirements of passing a law in the United States government because I'll probably misstate something anyway. But if they have the votes, they can change the laws, and if they change the laws, they can make big impacts. But as we discovered, I think it was fall of 2022 when there was the reconciliation bill, where we were just so close to seeing substantive employment-based immigration reform. It got broken by splintering in the Democratic Party. They just couldn't make it happen. So big picture, politics is politics. It's a strange beast. I don't count on it. It is not like a clock. I can't look at it and expect to do the same thing. As soon as I comment on it, it goes sideways. But I would encourage anybody to watch the presidential debate. Maybe learn a little bit about if you don't ever pay attention to U.S. politics, learn maybe about what these politicians really think matters to the rest of the U.S. populace, and at the very least, maybe have a laugh because I'm sure it's going to be an interesting one. So I have done it. I have gone through a half hour of a neat topic near and dear to my heart. What is the status of employment-based immigration in September 2024? And I'm really kind of focusing in on green card applications, people who have the I-485s pending. But we'll talk about I-140s in the back half of our presentation here. But really, interviews still happening. RFEs, treat them seriously. EB1, I've seen more demand for EB1A across different and varying occupations that I've seen in the last couple years, and the magic sprinkles on top of that is politics. Everything everything that I just said, all everything I talked about for the first 25 minutes of this presentation can be thrown asunder by politics. Really, overnight in the past, with presidential administration changes, the executive controls how we execute the laws. Literally, overnight, immigration policy can change like that. The laws don't change, the regulations don't change, but the policies can change overnight. And how those individual leaders interpret the immigration rules that are on the book can vary the results greatly. So, I think you've all heard enough of me talking about what I want to talk about. Uh, somewhere out there, a member of my staff is watching and agreeing with me. Um, but what we're going to get into right now is the part of the presentation where I shall do my best to answer the questions that you nice folks have put for me in the comments. I'm going to touch upon, there's a lot of great I-140 related questions. I'm going to touch upon those and whatever else is in the cards for me. Just keep in mind that this is just an online gab fest starring yours truly. When it comes to creating an attorney-client relationship, this venue cannot create that. It's a public space, and I only have a little bit of information about the issues, the questions you're asking, and perhaps the issues you're having. I would encourage nobody to make a decision that changes your life, aside from watching the debate anyway, about based upon what I'm talking about here. I would always encourage you, and Sam, if you're out there, if you're watching, I know you're working your way back to beautiful Columbus, Ohio at this time. If you're out there, well, hello first, but I would encourage everybody to find an immigration attorney of their own choosing that makes you feel comfortable before making any sort of immigration decision. You are investing a whole lot of your life and your money and your time into immigrating to the United States, and um, you should do it thoughtfully. And there are people out there, I like to think of myself amongst them, who will be happy to advise you and talk to you for very little. So getting back to the top of the questions here, just for the record, if anybody posted any questions before we got started, you may want to post them again because they may not show up to me. But I'm going to start right here from Ignazo Mali. So I'm waiting for EB3 Rest of the World, the priority date of February 7th, 2023. Do you think that will be current soon? So Ignazo, first of all, let me get that visa bulletin back up on my screen here as I go and click around a bunch of windows. There it is. Visa bulletin, EB3, rest of the world. I am seeing, I'm seeing based upon the tone of my voice, I can't be too optimistic about it. Here's why. So EB3, rest of the world, final action date are at 1st of December 2020, and the dates for filing are, 1st of February 2023. I guess I haven't looked in the visa bulletin for a little bit. So here's why I'm going to be optimistic. February 7th, 2023, you are so close, Ignazo, in terms of dates for filing, but painfully far away in terms of final action dates. When we look at the visa bulletin, we know the final action dates for EB3 Rest of the World have jumped back quite a bit. And based upon everything that has been said by the Department of State on the visa bulletin, that rolling back of the dates has been to basically to account for the fact that we're coming towards the end of the year and visa availability is low. And they do that to basically stop visas from being them from getting more demand for visas than they can handle. So I guess the one thing I didn't mention, what the biggest, ongoing thing in September 2024 is that we have a visa bulletin for October 2024 in the near future. The next couple of weeks we will have that, and for you, Ignazo, I would say there's reason to be optimistic, simply because you are so close to the dates for filing. Dates for filing are supposed to be, the theory of dates for filing when they first sort of came around, as I understood them, was that we're going to give you these dates of filing because we think if you file at the time when your dates for filing become current, by the time your final action date becomes current, USCIS or Department of State will be done processing your green card and ready to issue it to you. So dates for filing point towards are close. You don't have much time to wait. Basically, Ignazo, the October visa bulletin, which is happening very soon, will really give you an idea as to really kind of what kind of fiscal year to expect. But realistically, you could tell me that you were current in October, and I'd say, first of all, I'd say awesome, and second of all, I'd say I guess I wasn't too surprised considering you're so close on final action dates. Excuse me, on dates for filing in September. And I guess obviously final action dates are best. We don't know where those things are going because those show our retrogress backwards. But dates for filing, it's better than nothing. So, from Sophie Evie, can you please explain what supplement J is? I'm sorry if you already answered it or talked about it. So I don't think I've talked about it today, and I don't think I've talked about it a lot in this venue. But first of all, supplement J is fully known as Form I-485 Supplement J, and if anybody is interested in it, you should be able to find that on the USCIS website. Form I-485 Supplement J is basically a supplement to Form I-485 that has a couple uses. And those couple uses are there's two checkboxes on the beginning of the form, and those sort of outline the uses of Supplement J. Supplement J, one option for use is to confirm that an I-140 petition, that the job in that petition is still available to you. So Supplement J can be used to essentially say, used by you and your employer to say, hey, remember that I-140 we got approved for, Sophie hypothetically? That job that we set forth on there is still good pursuant to that I-140. The other option, the use for Supplement J, is to request portability benefits under the for somebody with a pending adjustment of status. And portability benefits are once your I-45, generally speaking, once your I-45 is pending for more than 180 days, you can change your job to another same or similar occupation in the United States. There's a lot more to talk about that in terms of to be careful in taking advantage of I-45 portability. But the short answer is Supplement J is used to either confirm that the I-140 offer of employment is still there or to change to another job based upon the portability rules. And it used to be, before this form existed, it used to be done a little bit informally with a letter from the employer. Now you do it with Supplement J. So from Naveen Cole, hello, Brian. Do you have any predictions for 2025 EB2 and EB3 India? So this is a topic that's near and dear to our collective hearts here at Shihab Burke, and because how can it not be? I don't have a great prediction, Naveen, because as soon as I try to predict, the Visa Bulletin makes a fool out of me. But here's what I can say, and I unfortunately don't really have much sort of well, here's what I can say. One, visa availability is down. Anything we've seen would indicate that USCIS is going to have less visas available for them for employment-based categories this year versus last year, which stinks, which can slow down, movement of the visa bulletin. Or rather, USCIS and the Department of State are going to have less visas available, and that can slow down the visa bulletin. The other sort of so that's sort of, I guess, really predictions. My optimism for EB2 and EB3 India really depend upon where your priority date is. For priority dates before I believe it's December 1st, 2014, which is the furthest the final action dates have made it for India EB2 or EB3. I'm optimistic for those people because the way I sort of explain it is a forest full of trees. Every person who had an I-140 with a priority date from now until December 1st, 2014 is some lumberjacks in the forms of visa availability came and chopped down a lot of the trees in that forest. And there's not many trees left because they gave away so many green cards to people with priority dates before December 1st, 2014. They thinned out the herd, they thinned out the forest, and movement in that window of space seems more likely to happen. When it comes to movement in the visa bulletin into times beyond December 1st, 2014, it stresses me out. It doesn't seem like it can move very fast. And before we can get there, it could be a couple years because you may recall USCIS in some FAQs around the end of last year said that they had enough I-45 applications in their inventory to account for several years of visa availability. So I think that The next couple years will be really kind of going through that EB2, EB3 backlog before December 1st, 2014. And then beyond that, in my mind, excuse me, it necessarily has to get slower. So, from MG, what is the likelihood of one getting a green card in hand by the end of the year next year? I-485 is pending for 20 plus months. Party date August 2022. EB1 India February 22. EB final action date EB1 India February 22nd with October visa bulletin expected to progress final action date. Here's what I like about EB1. So I guess EB1, especially for India. So right now, even though we're at the end, even though they have announced that they are out of visas for the year across certain categories, uh, the bottom line is demand for the rest of the world uh, and Mexico and Philippines for EB1 categories is not full. Those are listed as current, meaning if that category is current, it means that they are not giving away all the visas they can, which means visas um, from unused by those countries are flowing down into the India EB1 backlog, which is again at February 2022 in terms of final action dates, as MG points out. So that's the thing I like about EB1 for India. It is there is no backlog for the rest of the world, Mexico and Philippines. That means there are bonus visas flowing into that category. Bottom line is demand is high, but with a priority date of August and a final action date of February. I don't make predictions, but if you told me, told me in the something that if you came back to me a year from now and said, "Well, I got my green card in fiscal year 2025," that wouldn't blow my mind. It seems within the realm of possibility to see it happening this year, for sure. Uh, by next fiscal year, beyond fiscal year 2025, which we're about to go into, I'd say it gets a lot more likely. But yeah. So again, I can't help but comment that this person has a great YouTube handle. Immigration. I want that handle. How do we get that one? Sam, just get us that handle. Hi, Brian. I have two green card petitions, both pending adjustment of status, and I'm going to skip down to get to the rest of immigration's question here. And don't worry, I'm going to go back to the ones I skipped to get there. Have two green card petitions pending AOS, family and employment. Oh, neat. You have multiple pokers in the fire. Employment AOS interview in March 2024 was canceled. Interesting. Family AOS interview is coming up. Would medicals done in February 2024 suffice? So, my answer is likely yes, and I'll tell you why. But I sometimes don't trust USCIS on these things. So immigration, if you're feeling bored, I want you to Google Form I-693, and this is what it says on the USCIS website. Effective April 4th, 2024. Any Form I-693 that was properly completed by a civil surgeon on or after November 21st, properly completed and signed by a civil surgeon on or after November 1st, 2023, does not expire and can be used indefinitely as evidence to show that the applicant is not inadmissible on health-related grounds. There you go. It should. I guess one of the things that I will warn you about is sometimes government officers don't know everything about the work that they are doing because they are human beings, of course. Anecdotally, I was talked to somebody recently who had an awful experience with automatic visa revalidation at the southern border, despite being totally eligible for it. And my answer to him was again the same as I would say to you. You have to be a little bit paranoid that an officer might get flummoxed or confused. Bottom line, though, the policy here is very clear. It's a sort of the thing that that they're probably well aware of on that front. Um, so, any advice for family AOS interview to avoid RFEs? What to expect after this step? Married to a U.S. citizen, visa number is available. Married to a U.S. citizen, there's always a visa available. You don't even have to deal with backlogs. Immigration, if you're married to a United States citizen, you're what's classified as This is where I'm going to put on my family immigration hat for a moment. You're classified as an immediate relative, and there are always visas available for immediate relatives of United States citizens. So I'm going to keep my family immigration hat on for a second and just say generally about family immigration interviews. So for those of you who are going through the employment-based immigration process, that's a process that literally can take years or more than a decade for some people, depending upon your place of origin. And there are so many requirements along the way: maintaining your immigration status, making it through the labor certification, getting an approved I-140. Um, all these things are out there. Family immigration at its heart through a spouse has one requirement: that you be in a legitimate marital relationship with your spouse. And that's, as long as the government's happy with that, that's that. Bottom line, if you're working with an immigration attorney, talk with them. They can talk to you about the interview, what to expect, how they do them. I mean, based family immigration interviews are a little bit interesting, a lot different from employment ones. One thing I would disclose about family based immigration interviews is, for marriage-based ones, is they'll often separate you because they're so paranoid about fraud that they will separate. Say they'll meet up with you in the conference room. They'll say, "Husband, you're coming with me back to the room. Wife, you're going to wait here in the waiting area. Talk with husband for a bit. It's Tell me about your wife. What are her siblings' names? What are her parents' names? How many bedrooms in the house? What color are the carpets in your bedroom? Things like that." And they'll send you back to the waiting room. Your wife will pop out and say, "Wife, you're coming back with me. Answer the same questions." They can do it that way. And family-based interviews are an entirely different beast. Is the bottom line. And again, I'm there. I guess I would say family-based cases are much more likely, marriage-based cases especially, are much more likely to be interviewed than employment-based cases. But if you have an immigration attorney that's representing you, it doesn't hurt to talk for a little bit of time about, what does an interview look like. And you can always take somebody with you if you want. Uh, One of my favorite parts of being an immigration attorney is going to green card interviews with people. It's like the equivalent of a field trip when you're at school when you're a kid. I always loved those as a kid. And what is a immigration interview? It's taking me out of my usual place of business, being my office, and taking me out on a little trip with some nice people. So always fun. Hari Guru asked a great question, one that I don't think I can really give a definitive answer in this venue, about the Child Status Protection Act. Hi, Brian. Could you give us a guide on how to make sure a child's CSPA age is locked, I-140 approved, filed AOS using CHRA? A child is around 18 years old when AOS filed. Party date August 2013. India AOS, EB3 India AOS filed 9 in 2021. So Child Status Protection Act is sort of the sort of thing that I would typically, if somebody wanted my opinion on the Child Status Protection Act and they wanted a definitive opinion, it's the sort of thing where I would probably have a talk with them first, and I'd say, if you want me to do this right, you need to give me some time alone with your documents to review the entire history, because to sort of give you that level of confidence, that's kind of what I need to do. One thing, I'm going to choose this opportunity, Hari, to sort of make a public service announcement relating to the Child Status Protection Act. That sort of something that's very paranoid. Very paranoid about in the context of employment-based folks, and especially in the uh, India EB2, EB3 back, and maybe China as well. Because if you're jumping between the categories, please remember that the benefits of the CSPA will vary based upon which I-140, if you have multiple I-140s that you use to get a green card. Essentially, the processing time of your I-140 under the Child Status Protection Act can give you more time for your priority date to come up, and thus your child to get a green card. And if you're not thinking about the fact that, hypothetically, well, I filed my EB2 I-140, 10 years ago with premium processing, and that was approved in 2 weeks. And I had one EB3 I filed without, and it took them 6 months. Things like that can be the difference between your child getting a green card and not getting a green card. So, part of me being good at my job, Hari, is knowing what I can do effectively in this venue and what I cannot do effectively. I don't think I could confidently give you a good Child Status Protection Act talk in this venue right now. I would note that anybody who's any sort of immigration question, want to get a little bit of background, USCIS's policy manual is online if you want to get some insight, hurry, if you're really kind of in the do-it-yourself sort of mood. Well, again, I would still encourage you to talk to an attorney for that level of confidence. But USCIS, just search for their policy manual and Child Status Protection Act. As I recall, they have a pretty good section on it in there because I've read it a couple times myself. Going to keep it moving here. I'm going to got a nice crop of questions today. So, how does green card work if I move back to India? Already have approved I-140. So, bottom line, this Kumar, it is not. You do not have to be in the United States to pursue an employment-based green card in the United States. It's not as common as somebody coming here on a work visa and then, staying for a while, getting sponsored, then filing for adjustment of status. But if you are in another country, it is still possible for you to get a green card through employment. The problem is that instead of filing for adjustment of status in the United States, you might end up filing for a green card through the consulate. I guess, moving back to India, the number one question I would ask is that I-140 offer of employment still going to be available to you when your priority date comes up in 6, 7, 8, 9, 10 years? That would be the question for me, because it's not just about having an approved I-140; it's about having an offer of employment. Because, and now I'm gonna come back and mention Supplement J, which I discussed earlier. Supplement J, well, Supplement J is not used by the Department of State, but when it comes time for you, actually, your priority date comes up, you need to have an employer that's willing to offer you permanent employment in the United States when your priority date comes up. And if you're back in India, then my very first question I would have is, what kind of company is going to be content to you be outside the country for several years, and then only want you back when you're eligible for a green card? That's the sort of thing that I am thinking about there. From Sophia Evie, some perhaps intense questions here. I'm unable to confirm my entry and exit dates due to the unavailability of my travel history. I've requested information through FOIA, but there is a delay. Don't get me started on that, Sophie. I have had a FOIA request in with Department DHS, excuse me, since, and by DHS I mean CBP, since maybe March, and they still haven't responded to it. Maybe it was May, but it's frustrating for sure. How should I respond to questions as to about whether I violated my non-immigrant status? And how should I respond to questions about how I violated my non-immigrant status? Um, so maybe I'll talk about a little bit about the nature of questions that USCIS will ask you during a green card interview. I guess on the Form I-485, this is when I'm going to pull up a copy of Form I-485 to double check and see what it says. There's a question on there, I believe, that asks you whether you've ever violated the terms and conditions of your non-immigrant immigrant status. Let me see here. Yep, there it is. Have you ever violated the terms of your or conditions of your non-immigrant status? First of all, I guess there's one thing to be said, that they might not ask you that question. If you've ever been to a green card interview, raise your hand if you have. They will often ask you, go into that back half of the Form I-485 where there's about 5 pages worth of questions, and basically sort of handle it like this. They'll say, all right, I'm going to ask you a series of questions, and I'm just going to need your yes or no answer. And they may not ask that question at all. Some officers will just sort of skip over of large portions of them. They might not ask that question. My second threshold question for you, Sophie, would be, have you violated your non-immigrant status? Again, that's the sort of question an immigration attorney might be able to help you answer. Whether something is a violation of non-immigrant status is potentially a more complex question than you think. I guess there's certain things that are going to be cut and clear and dry, but whether you violate your non-immigrant status is a legitimate question, and the answer might not be 100% yes or 100% no. It might be, here are the positions you can take, and how defensible are they? So there is that. Obviously, the questions you answer always have to be truthful, because if USCIS thinks you're lying about something, that's when you can cause really kind of more trouble. I guess the last thing I would say to you, Sophie, is, and I'm talking in the context of employment-based immigration here, whether it matters, or I mean, for example, there's a rule called INA 245K that can protect employment-based immigrants from a lot of issues relating to issues with your status. But if you're a family immigration case, to give you an example, I think it was immigration who asked the question. Mentioned he was married to a United States citizen. He or she was married to a United States citizen. I'm presuming gender. Um, Basically, they're very nice to spouses of United States citizens. If you're the spouse of a United States citizen, they can forgive working without authorization and overstaying a visa, which are violations in terms and conditions of your non-immigrant status, for example. So there's a lot. There's a lot of strategy that could be involved in answering questions like that. So I gotta read your name here, Slarty Bartfast. Fun to say, Trump was pro EB green cards. He claimed that folks educated in the U.S. should get green cards. So I will give, I'll talk a little bit about the prior administration employment-based green cards. I would say that generally speaking, they didn't seem to have much against them because as a guy who practices labor certification, EB1A, I need more arms for this. Labor certification, I-140s, EB1A, EB1B, EB1C, any type of immigrant petition you can do. Those things generally weren't bothered too much during the prior administration. So I can't really argue with the concept that they really were too bothered about employment-based green cards. What I would say, though, is that a common path to an employment-based green card is a temporary working visa in the United States. In the prior administration, they sure weren't very nice to people on H-1B visas, which is a very popular working visa. That is for sure. So yeah, good take though. Again, I can't argue with you too much on that one. I wasn't shaking my fist in the air and saying all my green card processes are falling apart because of the prior administration. So I'm gonna wrap things up here the next few minutes here. From Gangadhara Simha, one of my friends tried to transfer to a new company A as a full-time employee and transfer denied. However, he continued to work for current company and has 2-year validity, and he's been working with the company for 5 years. He and his family need to travel to India and go to stamping as well. Does denial to transfer have any impact on H-1B stamping with concurrent company? So that's the sort of thing where I would think I would want to really review the facts of that situation a little bit more. The problem we have here, Gangadhara, is that we're sort of playing whisper down the lane, and I'm not even getting the information, firsthand from a message that was sent in, 20 minutes ago. I'm getting this information from a friend of a friend. I would really want to look at the scenario like that. I think it's possible that there could be some sort of status violation that comes up in terms of not doing things right. I would really want to see the reason for denial of the transfer. If it's a problem of maintenance of status in the United States, I'd say that could be a problem at your at stamping. But oftentimes, I say in many cases that scenario wouldn't be a problem for me. So a little bit of commentary from RK. I like commentary. Just commentary. I recently reviewed the USCIS data and surprised that almost 60% of this year's EB1 I-140 is for EB1C for India. Didn't know it was that high. So EB1C is the most accessible employment-based first category is the bottom line. All you have to do is be a manager or executive. Not everybody's an executive, but lots of big international companies have lots of international managers, and lots of those international companies like to bring in those managers to the United States. L1A, EB1C. It is something that I do a lot. Is the bottom line. I have done a lot of them this year. They're very popular. I'm not being crazy when I'm saying EB1 demand is up. I've done a ton of EB1Cs for folks out of India this year. So let me see. From Sai. My H-1B visa stamped expired, and I plan to get it stamped in India. Assuming I can get an appointment. I don't get one. If I don't get one, I can use my AP valid till May 2025 to enter. Travel questions are some of the most sensitive ones because the running joke as for immigration attorneys is client asked, Brian, can I leave the United States? No problem. The question is whether you can come back. But generally speaking, if you, I think your strategy sounds start smart, Sai. My preference is to always maintain non-immigrant status in the United States because it's just a good idea. But and meaning use an AP to come back as a last resort. I wouldn't. I mean, the bottom line, if you've been getting stamping in the past, I wouldn't really fret about your future H-1B stamping. Is the bottom line. So, gonna just sort of rapid fire these last couple because it's 7 o'clock and I have an appointment with my wife in just a little bit. From Cy, can we file for EAD AP renewal while I'm outside the United States? Thanks so much. That's a sort of thing where I wouldn't recommend it. I don't. I'm not. I don't believe. Cy. Part of me being a good person is knowing and good at my job is knowing what I don't know off the top of my head. And I don't know those answers off the top of my head. If I had to suspect, I would say no. And so for Sophie, that's the sort of thing, in terms of your immigration compliance. Talk that out with an attorney because I'm kind of perplexed as to how your travel records could impact your maintenance of status so much. Uh, Last sort of question here from Ignacio. Interviews typically waive for employment-based adjustment of status. Yes, in this present climate right now, climates can change, but often waived. And my last question for the evening, I have a can of fizzy water here. I'm gonna drink it to celebrate. How long after a family AOS interview to receive green cards is it safe to book international travel 2 months after interview date? So immigration, bottom line is with sort of employment-based cases. You don't know you're going to get that green card until the green card is in your hands. I have seen it take green card approved same afternoon, same day, literally when I'm standing in the parking lot with my client, or I have seen it, take weeks or months. It really depends upon the officer. You can't count on it. If I'm going to give my conservative advice that's not going to ruin your life, it's don't count your chickens before they hatch, and thereby do not make travel plans before that green card is in your hand. Unless you have some other way to come back to the United States, obviously. So it is 7:02. I must get out of here. I thank everybody for tuning in this evening. And if you talk to me tomorrow, let's listen to whether I sound hoarse because I think I might be after this hour-long talking marathon. Sam will be back next week. So will I. Monday, 6 p.m. right here from Shehab Burke in fabulous Dublin, Ohio, where the weather is beautiful and the people are friendly.